Probando, probando, probando en sala. Ahora sí, David, ¿me escuchas? Perfecto. Perfecto, perfecto. Sí, va.
Sí, ahora sí. This is English, though. Do you want to try both of them? Okay.
Correcto, gracias.
Okay, this is the English channel. I hadn't done English. I'd only done Spanish. Is this okay? Great. Okay, de nada.
Yes, this is the English channel. Can you hear me on the English channel? English. Okay.
Okay,
Yeah, the other person.
This is the other console. This is the other console, Joel. Can you hear me? Great. Now I'm going to Spanish.
Oops.
Good afternoon to everyone. I now open hearing number 33 of the 188th period of sessions of the Inter-American Commission on Human Rights. And this session is entitled Access to Justice and Judicial Independence in Bolivia. This hearing was requested by, I think, four organizations: Observatory Foundation for Human Rights and Justice, Human Rights Foundation Women's Legal Office, and Documentation and Information Center of Bolivia. I think also the National Union for Social Work. Thank you. The purpose of the hearing is to provide information on the situation of access to justice and judicial independence in Bolivia, with emphasis on the challenges in constitutional justice. Thank you. My name is Roberta Clark, and I am the second Vice President of the Commission, and I'm accompanied to my left by Commissioner Julissa Mantilla, and we also expect Commissioner Jose Luis Caballero, who is the country rapporteur for Bolivia. He'll be here shortly. I'm also accompanied by the Executive Secretary of the Commission, Tanya Renon, and the Assistant Executive Secretary for Monitoring, yes, there you are. Monitoring, Promotion, and Technical Cooperation, Maria Claudia Pulido, as well as the Assistant Executive Secretary for the Petition and Cases System, Jorge Meza. So you have all of the jefes of the commission here with you. And that does not include the two commissioners. We're talking about them. Yeah. So I want to thank representatives of civil society for requesting this hearing and also for being here, and certainly representatives of the state. I bring you greetings from the Commission. I just want to explain how we're going to spend our time. Okay, I think the interpreters are having trouble with me. How are we going to spend our hour and a half? The civil society organizations will have 20 minutes. The state has equal time, 20 minutes. The Commission will have also 20 minutes for its comments or questions. And then we will go back to civil society for the 12, and the state response for the 12 minutes, and then we close the session. So with that, civil society, you have the floor. Okay, that if you can just be moderate in your pacing because of the interpreters. Thank you.
Thank you very much, Madam Chair. The human rights defender institutions who've requested this hearing, the Human Rights and Justice Observatory Foundation, the Center for Documentation Information Bolivia, the National Union for Institutions for Social Action Work, and the Women's Legal Office Foundation greet respectfully the commissioners who are present, as well as the delegation from the government of the state of Bolivia. This hearing was requested to report about an issue that has a dire impact on constitutional rule of law, as well as full respect for human rights in Bolivia. There have been many dismissals by the Constitutional Court of in abstractum inconstitutionality claims, which leave human rights absolutely defenseless in laws that violate it, ignoring the supremacy of the law of the Constitution, which guarantee that any law is incompatible with the Constitution, they are invalid. In the time that's assigned to us, we will present data that has been carefully chosen, which prove that in Bolivia, both the Constitution, international human rights treaties, the Inter-American legal precedents, and observations and recommendations of specialized bodies have a relative worth, and only when they don't have a negative impact on the interests of the government are they accepted. Throughout our presentation, we'll try to talk about how to resolve these problems despite the observations and recommendations issued by the Commission itself, by the UN Rapporteur on the independence of judges and attorneys, by the GIEI, by the UN High Commissioner for Human Rights and other agencies, which reflects a undermining of judicial independence and maintaining and keeping in place a legal framework that rides roughshod over the Constitution and disregards the rights of citizens. Among the different violations that have been studied in the document that we've given you, we can highlight, among others, disregard of the natural judge with regard to security of the state, the possibility of preventive detention to go on indefinitely for crimes of this type, national security clause. Also, open-ended clauses to determine whether a person is a risk of flight. And then pre-trial detention goes on indefinitely without any judgment or any charges. For the power of the prosecutor's office to close criminal proceedings that have been inactive for more than a year, and this shows that there's been no due diligence in the investigation. Also, the discretion of judges to economically punish to attorneys in criminal proceedings, and even to remove them from their clients, and thus infringing the guarantee for a defense. Restriction on improper restriction for attorneys to be able to become judges because they have acted in criminal proceedings. And this goes against an international principle of separation between client and attorney. The absence of an impartial judge in oral proceedings. 8, inability to challenge members of the Constitutional Court when there are reasonable grounds with regard to their impartiality. 9, discretion of the Council of the Judiciary to transfer from courts from the court where they're sitting as a punishment. It's sort of a veiled, and I will give the floor to my colleague now. Good afternoon, ladies and gentlemen, members of the Commission. My name is Ruben Dario Cuello, and I represent the Human Rights and Justice Observatory Foundation. I'm going to refer to some constitutional issues, and I'm going to ask for you to put up the PowerPoint. The social legitimacy of the court has been under scrutiny for 3 reasons: the election of the judges and the percentage of votes that they have obtained in the selection process, and their political interference in cases, as well as many different charges of corruption that have existed within. The first slide, please. In fact, in the 2 elections of the court's judges, there were a lot of invalid votes, and this impact the form of selecting the members of the corps, and so much so that none of them surpassed 15% of valid votes for their position. The court has been seriously questioned by issuing controversial rulings in sensitive cases of public interest, which were processed and settled in transparent and very untransparent and confusing ways in favor of government interests. We're talking about rulings that were issued in the decriminalization of abortion case, where there is ignored the right of indigenous peoples to their territory and conservation of the environment, or the disappearance of a judgment that declared null the proceedings, trials where there was contempt of court. With regard to review of the constitutionality of presidential re-election, the determination under the court, which says that the president and vice president of the state may only be reelected once consecutively. Despite that, they issued a constitutional opinion which justified the third election of this person. And then through a constitutional judgment, the right to election, they said, was protected by the American Convention, and consequently it enabled Morales for a fourth time to be reelected for a fourth time, disregarding the constitutional referendum of 2016 that denied him a fourth term. Slide 5, please. The charges of corruption have marred the image of the court more. Several of the judges and officials have been connected to drug trafficking as well, because of creating consortiums of judges and attorneys and prosecutors. These corruption rings have reached the highest level of the judiciary, undermining public confidence. Another act of corruption that made it possible for authorities who had held trust positions in the executive have been appointed as members of the constitutional courts of the departments. Likewise, we've learned about several different charges of charging money, irregular payments to favor one party or another. And add to this a very negative incident. The court has been closing down progressively because of, with regard to proper procedure. All of these claims are dismissed without grounds, and they use ambiguous grounds, or they're failing to justify or explain the reason they've been dismissed. This phenomena restricts and undermines the fundamental remedy for respect for rule of law. And in these claims, not only is there a violation of the access of justice for people who bring these claims, but also it perpetuates many situations of human rights violations which come from unconstitutional provisions in effect. To understand fully this issue, we have compiled rulings with regard to these inabstractive inconstitutionality claims, and they are from 2012 to 2022. The general requirements for inconstitutionality claims is identify a specifically challenged provision of the law that's challenged, as well as constitutional provisions that are considered violated, formulating clearly the reasons why the challenged provision is is again contrary to the Constitution. In 5 days, the Admissibility Commission has to say why, and it has to order that it be rectified. In the next 5 days, this commission has to issue a pronouncement about whether it will be admitted or dismissed. They can only be dismissed when it is res judicata under the Constitution because of time constraints or because they have total lacking of grounds, legal grounds under the Constitution to justify them. As of that point in time, the court has 45 days to issue a pronouncement on the merits of the action, and we will prove how this has not been respecting. On an annual basis, the court receives about 5,855 cases. Between 2012 and 2022, there was an average of 43 inconstitutionality claims in abstractum that were filed. In other words, 431 actions in total. This is an average of only 0.84% of the total of the remedies that the Constitutional Court has to examine. And that's why the infringement of these procedural rights is minimum. However, on average, it takes 410 days to issue a judgment on the merits, and it takes 1,700 days to issue these pronouncements. This procedural backlog makes it unconstitutional because it doesn't rule on time. Thank you very much, Ruben Darío Julito. My name is Javier Uliafe, and I represent Human Rights Foundation based in New York. Continuing with the presentation, we would like, for teaching purposes, we want to divide up this 10-year period in 2 periods. First of all, from 2012 to 2014, as you can see up on the slide, to July 2014, and the second period from August 2014 to December 2022. This division is explained in the notable change in the direction of the rulings of the court after 3 of its members were subjected to impeachment for having admitted a case and had issued precautionary measures. So first we begin with January 2012 to 2014. There were 7 actions, 12% were 12% were rejected. But from August 2014 to December 2022, 189 claims were filed. That's 60+% of the actions were dismissed in the stage of admissibility. There is a radical exponential change, as you can see in the figures, in the statistics here, of the judges of the court. In other words, the proportion drastically flipped. Aside from the fact that 15.52% were dismissed and were not considered valid, the grounds that in 90+% of the times for the dismissal, quote, lacking absolute constitutional legal grounds, close quote. This, despite the fact that it is not the power of the Admissibility Commission of the court, of the Constitutional Court, to examine the appropriateness, grounds, or reasonableness of the arguments that have been put forward for these suits. The Commission should only check to see whether the challenged provisions of law, they must be constitutional provisions, and there has to be a clear explanation of the unconstitutionality reasons, but not get into and assess the arguments. And the cases that we have used to show in our study, we can see that those that were dismissed do comply with the minimum requirements of content. They identify the challenge provision, and they are considered constitutional precepts that are being violated, and an explanation is given why they're incompatible with the Constitution. And lastly, each one of these arguments are backed by in the case law of the Inter-American Court of Human Rights and the case law of the court, our Supreme Court itself. And of the 431 actions that were filed 2012 to 2022, 256 were filed by deputies and senators. Of these, 79 were brought by parliament members of MAS, the government party, and 25 were admitted, 29 were dismissed, 15 were considered not filed, and 10 have not been ruled upon, while of the 174 filed by opposition filers, 67 were admitted, 67 were dismissed, and 19 were considered not filed, and 18 have not been resolved yet. We underscore the fact that in only 4 of the suits that were brought by the opposition, the petitioners are granted win the day. The legal consequences as a result is the violation of the guarantees in Article 25.2 of the American Convention on Human Rights on remedies that are available, and this denies arbitrarily the ability to process these suits. Secondly, there's a violation of adequate reasons or grounds of judicial rulings, and this is understood that judges have to base their decisions on law. Thirdly, violations of Articles 8 and 25 of the Constitution, inasmuch as these massive dismissals end up avoiding processing of any other claims that are not in the interest of the government, and so this makes these remedies not be heard by other authorities, independents, and also it violates the right to participate in matters of public interest, and it restricts the ability for authorities to exert their prerogatives and powers, and it prevents citizens to take part in public matters indirectly through their representatives. Thank you very much, members of the Commission. I'm Franco Albarracin of the Center for Documentation in Bolivia. I'm going to continue with our presentation. I'm not going to emphasize anything that's not relevant, but all of the facts that have been observed, which are improper practices of the court, show how ineffectively the review of constitutionality is of all these decisions and decrees and other orders. This situation, aside from being direct violations of human rights, also have legal repercussions that are closely tied to the basic grounds of the state of law and democracy and rule of constitution. And consequently, this use for political purposes, there's been an intensification of criminal proceedings against human rights defenders, leaders, journalists, and union members, and opposition policy makers, focusing on women human rights defenders who are the object of criminalization with a significantly greater impact on their fundamental rights. In all these cases, the defendants have expressed criticism of the party in power and have engaged in promotion of human rights and protection. The current constitutional court, in attempting to favor the powerful political interests, has contributed to deepening the crisis of justice there in Bolivia and have weakened the institutional framework, democratic framework, and the rule of law in the country. Also, we beg of this commission to make a pronouncement soon on these events to avoid situations like in Venezuela, Nicaragua, and El Salvador and other countries. There's an expectation in Bolivia to hear your country report. Also, we'd like to hail the signals of judicial independence that we've seen from lower courts, despite political pressure from the state. Likewise, we underscore written agreements achieved by the Bolivian Senate that recognize the existence of political prisoners in Bolivia and the urgent need to unblock the renovation of the turnover of the members of the high courts. Lastly, we call on the Inter-American Commission to use its good offices to guarantee the stability and independence of the members of our courts, as I've mentioned in this presentation. Thank you.
Thank you very much, representatives of civil society. Turn to the state.
Muchísimas gracias.
Thank you very much, President. We greet you, the Commissioner Mantilla and the Commissioner José Luis Caballero, the Executive Secretary Tania Renault, Jorge Mesa, Executive Secretary, and Ms. Pulido. Thank you very much for this hearing. And I greet the distinguished representatives of the civil society. I'd like to begin by making something very clear. This is important. This is a hearing that speaks of a concrete subject. We have received a petition of invitation to be here with a specific subject matter that is related or solely related to the inefficacy, the inefficiency of the Constitution in Bolivia regarding all guidelines and constitutionality. This is the subject matter that the state has been invited to this hearing. We have Dr. Paul Franco and the judges Gonzalo Hurtado, Gallardo, and Flores. And they are here as members of the control of constitutionality regarding what was requested of us. So this hearing has absolutely nothing to do or link with any specific case. It could not be otherwise because we are speaking of an abstract and on a subject that is specific. So it is not tied to any violation of human rights by the state. So the state is not under the gun here to prove anything because it is about respect of valuing human rights. This is not linked to any specific case either. And there are several cases, and the state responds and answers to those that are presented. We are, by the way, the one that has the least cases of human rights, and we have very few. It is not a case also that has to do with what was caused by the independent in Bolivia. So this has to do with the peace, inter-American peace, and the state. It also has nothing to do with the visit that the Bolivian state had the honor of receiving, the commission group that came in March to Bolivia, and the report is still being done. So I make this clarification because we have heard a rosary of cases that are incorrect. This is not a political hearing, and we're not trying to make it political here. And the Inter-American Commission should be respected, and the state works directly with the Commission. And we want to always comply with what we have said we will work with along with the Commission. And there we have received a specific request, people from civil society. We will refer to that subject matter. Otherwise, we could speak about different controversial cases, opinions from the judges, the use of the penal system, the criminal system. So distinguished people from civil society. Otherwise, to say something in the request would be a lack of loyalty and even disrespect for the Inter-American Commission. So having made this clear, I will then hand the floor to Dr. Paul Franco, who's the president of the Constitutional Tribunal of Bolivia. Thank you very much. I greet the president of the Inter-American Commission and everybody else who is here. Of course, those who have requested this hearing for this 188th session. I heard with great attention what the 4 people from civil society have said, which actually created this hearing. So some things surprised me, some things they referred to, because they are tightly related to the document that notified us as state to be here at this hearing. So we think that there's some speculation about the lack of judges or things that the Constitutional Tribunal has said or done, or the supposed inadmissibility of some cases because of a lack of independence, of judicial independence. So we would like to say and make it clear that even though we have been denounced at many trials and cases of this, none of them have ended up in determining that these are what we have done, that these cases prove what we have been accused of. We have been doing our work within the framework of what the Constitution establishes and the guidelines and rules that are within the competence of this tribunal. So it was mentioned that within the constitutional composition, there is an inefficiency of the rules and that the actions that have been presented do not merit, and they can be dismissed, any of these guidelines, if they infringe the supremacy part of the. We deny this affirmation. As an example of this, we say that within the political constitution of the state, where Mr. Cuellar is an ex-member, we acknowledge that this is a mechanism to activate the guideline that defines constitutionality. So this promotes and allows the tribunal to have the opportunity of seeing, knowing everything that is submitted to them to be for their knowledge. And this would be divided in two: an inconstitutionality claim, an abstract one, which has been referenced to and in the document that they have given us today, and another concrete inconstitutionality action about administrative things. In the abstract one, what is being legitimated and certain people that are acknowledged within the guideline structure are recognized, and these are deputies and senators, and along with the People's Ombudsman, they are legitimatized by the guideline or rule that rules this abstract constitutionality and the code, the procedural code. And even though they are activated by way of this mechanism, and it is within the political constitution of the state, when these merit a decision by the tribunal, they have a recourse, a mechanism by way of which these accusations can be generated when everything else is contained in this act, in this action, which, as the proponents or the petitioners of this hearing have said, if there is a dismissal action, then this same mechanism that is regulated by Article 27, third paragraph of the procedural code, then admits this, what is called as a recourse of complaint. So when they are not satisfied because there is a lack of motivation and founding for due process, such as different figurative parts of due process. There are these parties that can accuse before the plenary of the Constitution, of the tribunal. And admission or dismissal is admitted by a commission of admissibility that is made up of 3 judges, and this can be accused before another tribunal if there is no conformity with what has been said in a dismissal action. Then Article 8 of the Inter-American Human Rights article says, or Article 25 of the same convention says, that the effective mechanism to generate the possibility of the tribunal to review the action that is being contested, then it is regulated in Article 27, third paragraph of the Constitutional Procedural Code. If the parties, and I emphasize this, are not satisfied with this dismissal, then they can activate this other instrument of recourse within the jurisprudence of the Commission. But since we have been judges from 2018 to date, we have only seen 8 of these claims that have merited a decision. And we do not find what the petitioners are claiming, that the tribunal did not pronounce itself on these matters. So if we are given the opportunity to review the actions of the Admissibility Commission in the terms that are fundamented, that have a basis, then we can review all of this by way of the Admissibility Commission to see if that dismissal went along with the rights that are being taken into account or considered as being violated. So we consider this matter as speculation that really has no basis, and we have not seen in the slides that were shown any information that reflects the fact that the Constitutional Tribunal is not complying with what they have to do regarding this one recourse in number 3. So we have had several claims of inconstitutionality which have merited some constitutional sentences. There was mention of a discretionary rule, such as a sanction that could be emitted to then prejudice the abnormal action of judges. But in 2149 action, we have taken into account and complied with the rulings. We have thrown out and dismissed several of these cases because we found that in the decision we had to take care of that situation. In the same manner, within the Bolivian judicial system, sedition as a crime by way of an unconstitutional sentence, we have thrown this out as well, because for that type of crime, this was not within the parameters established, and we could have said that we were facing a blank criminal sanction, and it is not in accordance with what applies within our system. So we have done our exercise in the correct manner, and as I mentioned from the beginning, is activated by an abstract inconstitutionality claim. So several cases that we know of every year, that we see every year, since last year, we receive 8,000 cases a year, and there's a high percentage of defense the freedom, the privacy, action, and compliance, and within the framework of what is inconstitutional, abstract inconstitutionality, there are less cases. But this is an opportunity for us to let you know that we see many, many cases, as I said, 8,000, and we have sentenced on or provided an opinion on 1,500. There are 22,000 admitted by the Constitutional Tribunal, and we don't know that from any of them was there a claim on behalf of the Inter-American system. So we're very respectful of what has been done or is being done by the judges of our judicial system. And when we have the opportunity of seeing any case that has to do with things that may have come up because of human rights, we will do so with the responsibility that it merits by what the law and what the tribunal says. Therefore, to conclude and let my other colleagues say something here, even though there is an abstract inconstitutionality if it could be rejected within the Inter-American System Court, this is in Article 27, paragraph 3, as I have already said. Thank you very much.
Muy buenas tardes a todas y a todos. Mi nombre es Karen Gallardo. Un saludo cordial.
So I greet all the people of the tribunal from the Department of Cochabamba. I would like to add, in the time remaining, just simply that the Constitutional Tribunal has not found a way of how they have been elected. Those of us here, we have complied with the requirements and we are doing our job. And then we emit our opinions, as has been pointed out. For about 6 years, we have used good practices within this tribunal, this court. And regarding gender, we have ruling with the gender focus, and we have approved something in plenary to judge with a gender perspective and intersectionality at many of the courts and that are well known. We have promoted ethics in the Constitutional Tribunal, which is applied, and we have also applied pluralism, judicial pluralism, that we are accountable for, and we have a technical secretariat where professional sociologists, historians, and researchers help us with their technical reports on the sentences and some of conflict of jurisdiction. And when we also have political constitutions of the Bolivian state that have been translated to Aymara, Quechua, Guarani, and other languages. And we have different agreements, jurisdictional agreements, where we have seen cases that have to do with violence and homicides and other cases of the rights of children and adolescents. And we have an academic responsibility. So we educate, and this is to promote and let people, the citizens, know what the state does judicially. And these are rights that people should know. Otherwise, they cannot exercise these rights if they don't know they have them.
Buenas tardes a todas y todos.
Good afternoon, everyone. Echoing the Chief Justice of our Constitutional Court, we have to point out that the Constitutional Court has unified the case law, its case law. In other words, there aren't any isolated rulings. It's been
21 se unificó respecto al tema.
and so in other words, are those who work for us on this predictable in this predictable system can come to us to be able to receive protection from the court, the constitutional court, and particularly the productive sector, which is the engine of our Bolivia. Thank you very much.
Representatives of the state, and now I turn to the Commission for its response. I want to remind the members of the Commission that we have about 20 minutes and there are 5 of us to speak, so if we can do some self-regulation, that would be great. Commissioner Jose Luis Caballero, who's also the country rapporteur for Bolivia, can you start?
Muchas gracias. Muy buenas tardes.
Good afternoon. Good. Thank you, Vice President Roberta Clark and Chair, and Julissa Mantilla, my colleague, the Executive Secretary Tanya Ranao, and the Assistant Executive Secretary for Monitoring, and the Executive Secretary for Cases and Petitions, Jorge Mesa, as well. And I am welcome civil society. I'm very happy to meet with you this afternoon, and the officials from the state as well, the justices from the court as well, the Constitutional Court as well. Thank you very much for providing us with this overview. I believe that this is a real important issue. These unconstitutionality claims to decide what is constitutional, what is not, and I hail the state that its constitution is strong enough to be able to provide for such a remedy to protect minorities, to defend rights, so that the Constitution is adhered to not have to wait until someone is actually harmed. So to do it in abstractum, I hail the fact that this is provided for in the. But I have a few questions for the state, though, Chair, if you would allow me. So, even though there are very clear deadlines for filing, and the particular parties that have to move in this way, and very specific things that must be done in the procedure. So the Constitution's view is a whole with all these different rights, and it includes international treaties and conventions, as well as what the Constitution itself says. It's a full block, so to speak. And so with regard to the court itself, what measure do challengers have available to them? It's very, we see that a high percentage of cases don't ever get to the merits stage. And so that's for you, State. But I would like to ask civil society a different question, which is related to what the State said. The appeals on constitutional decisions to not accept your claims or any claims when there's refusal in this particular appeal, when you're appealing the refusal to hear it, explain your reasoning behind that. Thank you.
Thank you very much. Commissioner Mantilla.
Muchas gracias, señora.
Thank you. Thank you very much, Madam Vice President, and greetings, distinguished representatives of the state and civil society. Welcome to the Inter-American Commission of Human Rights. As what happens in many of these hearings, there's parallel stories going on here. It's not surprising to me. It's weird, it's bizarre, but it happens often. But with the explanation given to us by the Constitutional Court, and I thank you for this explanation, what I would also like is a more direct answer to what the argument of civil society, for example, what has been based on the information that you have available to you and that you can facilitate to us. What are the reasons, what are the grounds for dismissing these unconstitutionality claims, which is such a high volume, as we can see in the statistics? And in this regard, the data from the civil society presented to us, do you have a different version? Do you deny those facts, those statistics that were and also in the Commission, in its press release in its last visit, we have issued pronouncements on the popular voting for the members of the court. And so we've been monitoring this issue about voting, holding popular votes for the members of the. So with regard to this delay beyond what the procedural code says, there's an actual delay, a huge procedural backlog. And another thing that we've been monitoring is the situation of gender-based violence and proceedings. I want to know if there's specific information with regard to gender-based violence in civil society with regard to regarding women human rights defenders. Have there been any claims brought to you involving women human rights? So thank you, Chair, and thank you, members of civil society, also the members of the distinguished members of the state. The Commission has been monitoring the issue of justice in Bolivia now for quite a number of years, 15. In the country report of 2007, there's a special area with regard to access to justice. In the 2009 report, the topic is raised again. In the preliminary comments on its visit, it does so again. It's a leitmotif, shall we say. It's a constant. And today, civil society has brought before us quantitative evidence that strengthen the hypothesis of the Commission that there needs to be a strengthening of the judicial system, the judiciary. But in September, the Inter-American Commission issued a ruling or a pronouncement about the election of the different candidates to the high level, to the courts, the elections to elect these members. I would like to ask civil society about this electoral process, because what you're providing to us at this time, you're giving us quantitative evidence and qualitative evidence with regard to access to justice, procedural access, a lack of grounds for judgments, reasoning of judgments. They're not reasoned out by the judge. One solution to these problems would it be a different process for electing the members of the court? Would that be a possible a potential solution?
And I join my colleagues again in welcoming you and thanking you for your interventions. My question is for the representatives of the state. The civil society has presented, as the Executive Secretary has said, evidence. They provided data, statistics, which they assert show a differentiated approach by the court to claims of unconstitutionality of laws and I suppose policies and practices. And secondly, a differentiated approach which is evidence in a longer period of time between admissibility and decisions of the court when those claims are presented by opposition or persons perceived as opposition, I suppose. The slides weren't clear on that. And they're saying, they're offering up, or they're asserting that the difference in treatment is related to potential political stance, I suppose, that may undermine the independence of the judiciary. I think that's how I understand what you're saying, and if I'm wrong, please do correct me. So they're suggesting that this is evidence of structural challenges that affect judicial independence. And so my question to the state on this is, I guess I'm asking for a direct response like Commissioner Mantia to that assertion, and also to say that from what I've been able to read, Executive Secretary, this issue of challenges to judicial independence in Bolivia has been an issue which the Commission has been tracking for quite a while and comes up regardless of the political administration. It's what they call a structural issue, and maybe it's also linked to how judges are appointed and how secure their tenure is. So I think my question to both the state and to civil society is, what are these factors that undergird this, these structural challenges, and what kinds of suggestions have been made, I'm sure many in Bolivia, to address these structural challenges? Thank you very much. And so, we have now 12 minutes for civil society to respond or to say. You don't have to respond to these questions now. You can send in written submissions. But there may be things that you want to respond to now. And similarly, representatives of the state, you can respond to what you can now, but you can also send in written responses. Thank you very much.
La palabra, señora presidenta. Muchísimas gracias. Quiero dar respuesta a algunas.
And now I'd like to respond to the questions that the representatives of the state have provided to clarify. Why have we included specific cases? We're not bringing up any particular cases. Specific cases, what we're showing you are the extremes that we have denounced. The delay in ruling on cases, the discretion of the Admissions Commission, which is not empowered to rule on the merits of cases, and however, in availing itself of the remedy in Article 27.2, they are lacking, absolutely lacking in constitutional content. To say that they have no constitutional grounds is prejudging the merits, and that has to be settled in the judgment on the merits, never when it comes to the admissibility phase. So representatives of the state, I must point that out. So I want to emphasize the question that's been posed by Commissioner Caballero. Why don't we appeal through the mechanism as the president of the court reminded us that was available to us? I want to tell you that appeal is that there's several different irregularities that you can read about in the extensive document that we've submitted. There's Article 24 of the Constitution says that the plaintiff of one of these cases, these claims, has to provide a email address in a timely fashion to receive the ruling of the court. In an overwhelming number of the cases, is this ever done? And when they do it, it's through private emails of underlings of the court, but way after the deadline when they're supposed to be responded to, because when there's one date appears, but the communication takes so long for it to come out, so they kill our ability to be able to appeal this ruling. And the times we've appealed this, and I've been sponsored many of these suits, these claims, and 98% they uphold the rejection, the dismissal. So the Constitutional Court since 2012 has been used an unconstitutional tool. It demands that the person with standing has to prove that he or she has standing. When it's an alternate or a deputy, a congressman, they're elected for a constitutional period, just like the full deputy. It's not that only the weak that do they have standing when they're in parliament, and then when they're not there substituting, they don't have standing. So many of the cases are dismissed because they cannot accredit the person as having standing, these alternate deputies. And this is an interpretation that's not only arbitrary, but it's absolutely discretionary. And it leaves us with no ability whatsoever to challenge anything. 431 claims have been filed. Only 4 have been granted admissibility, and I thank the president of the court that in the transition of attorneys, etc., that you repealed the provisions that were unconstitutional. Only Article 20 was repealed, and it says the determinant of the transfer is mandatory, and it's not an impediment for judicial affairs to go back into the judiciary, the school for which they have taken the test or passed. In other words, discretion to remove them from office when the Council of the Judiciary, without justifying it, decides that they should be removed. So they're doing no favor to the stability, job security or stability for judges in office by repealing this. Thank you very much, members of the Commission. With regard to the comments of the representatives of the states, the remarks, I have to remind you about the interdependence of human rights. There's a link to all different rights, particularly the American Convention of Human Rights, due process and access to justice. So if we talk about that, we have to talk about other rights, such as violation of these and others that are being violated in this. The unconstitutionality claims, as have been mentioned before, is a claim that is a check on power. It makes it possible to prevent that any hegemonic parties can take advantage of abusive provisions of the law. And therefore, it's very important for us to be able to debate it and present any information that's of interest to us. Distinguish justice. We're not questioning only the way that high-level authorities have been elected, but the conduct over the course of years that is favorable to or subjugated to, not to say subjugated to, the political interests, and so powerful political interests. And so the Secretariat of the Inter-American Commission and the commissioners, I must say this, and with regard to the process of election, as you ask, there's also, and correct me, the representatives of states, the last elections have been a failure to elect these judges. Civil society and experts on the subject matter have shown that the latest elections have not provided a response technically or democratically, but they were just a response to partisan and political interest. And so we're looking for other alternatives to find out how to elect these high-level judicial officials, and not this way. They continue to be blocked, or they're still hampered. So we believe, since there's no other alternatives in the short term for selecting the judges, there should be election of high-level judicial authorities. But these elections are stuck because of strictly partisan reasons in the plurinational legislative assembly. I remind the members of the Commission, as well as the representatives of the state, that even though if we don't have election of elections, we're going to have authorities that are here that are unconstitutionally holding the positions, and all the decisions will be unconstitutional that they issue as well. Also, with regard to other questions that have been posed by Commissioner Clark, for example, we believe that there are a lot of challenges of a structural nature, and the consequences thereof are very clear. The lack of independence of the Constitutional Court, the members thereof, and it had very dire consequences on the country. Let us recall the events of 2019, and this arose as a result of an institutional crisis and a democratic crisis and a crisis of the organs of power, of the branches of government and the judiciary and other bodies. And so I hope to have been able to answer your question, and now I give the floor to my colleagues that are on Zoom. Yes, thank you very much. In any case, I believe that with regard to this structural crisis, at first, we must shore up basically the independence and economic strength, so to speak, of the courts of justice. as regard to courts, as far as judges, the judiciary being dependent upon the executive branch is who approves the resources, and it's 0.5%. It's a low amount of resources that are allocated. Yeah, very low, even lower than that. And so this is not and also we have to look at the qualifications of those who that shouldn't be based on political militancy, but it should be based on their judicial career and their qualifications as judges. To be able to be qualified, they've been elected, they've been chosen, they've been elected, but the people, with its wisdom, has figured out they must be rejected because the one that has the most votes is obviously of those valid votes deemed valid, which is 15% were the only votes that were deemed valid. This could have been the origin of this, but to revert to the acts of the judges themselves, unfortunately, there isn't much merit that shows any professional fortitude, professional ethics, and particularly independence in judging, even at the risk of perhaps being persecuted politically or however. But they could have done what was necessary to strengthen the judiciary. That it's not a weakness for 20 years back, but longer back. Way back, but it's becoming weaker and weaker, and this is becoming deeper and deeper over time, and that we hope after the agreement that was struck, I believe was struck in the Bolivian Senate, that this is showing signs at least of an understanding between civil society and the political organizations and the state institutions to offer the Bolivian people a strengthened and independent judiciary that's capable of properly doing its job, playing its role. That's to fix problems, to settle problems, because a society without a judiciary, without a judicial branch that's propped up and bolstered, you cannot aspire to a peaceful life or a life where there's respect for the dignity of all inhabitants. Madam Chair, I want to say last year and 2 years ago in the country, we tried to have a partial reform of the Constitution to change the judiciary from economics, the election of the court, the members of the court. Unfortunately, that effort didn't come to fruition because the law, we weren't able, there was too high a number of citizens, was the number whose, with proven ability to vote, had voted in that election, so they weren't enough. And so we're going to try it again because we need for the judiciary in Bolivia truly is independent and is endowed with the sufficient economic resources to be able to properly do its job. Thank you.
The representative of the state.
Gracias.
Thank you once again. We at the Constitutional Court, we applaud the initiative that civil society has had on this occasion to bring to the attention of the Inter-American Commission of Human Rights these issues, these aspects, that is. We specifically, and in a formal way, we will submit all the appropriate information that you've requested, and to respond to each of the questions and comments and all doubts. In the very short time the state and the civil society has had to be able to orally respond, Commissioner Mantilla said, and she says there's a parallel stories here at the beginning, and this unveils can be available with the different statistics the civil society provides, and we do too. So respectfully, we will turn in our statistics, all with regard to the claims that have been brought before the constitutional period from 2018 to the present time. And those are the ones that we have responded to because we're in that term right now, and that we are going to send in the briefs, the legal briefs, which reference that there's no compliance with the requirements that are demanded under the provision of the Constitution, as I mentioned, which the Constitutional Procedural Code sets forth. Now, also, in the Admission Commission, we don't prejudge. It's only about verification of the requirements for admissibility, and we have a test to see whether the challenged provision can move to the merit stage. There is a challenge mechanism in place for the merit stage, but also when it's be submitted to the constitutional court and it's rejected, it can be challenged again. It's not that it's the end of the line and there can be no further review of the constitutionality of the claim. We are more interested in that there is a broad independence of judges. We're the first ones to say that we want to resort to the inter-American human rights system when we're persecuted by a decision we take and we believe that the judge is not that we are not ruling as a party wants, and therefore we're persecuted. So we're the most interested in strengthening the independence of the judge, and we're the most interested in solidifying a proper budget for the judiciary to be able to, and our particular court, our constitutional court, and the rest of it, and the entire judiciary. And perhaps the Constitutional Court may be worse off than the rest of the judiciary, the other courts, but there are inequities sometimes that come about because of different reasons. But we have been able to perform our duties responsibly, and we will continue to do so. We've decided to come here and show our faces, so to speak, because we're more interested than anybody to fulfill these standards that are being demanded by civil society with regard to the responses that we have to provide at the proper time to the claims that are submitted to constitutional review by our court. Constitutional review. And so we will submit in writing the appropriate information that has been requested. And I call on the civil society. The doors of the Constitutional Court are open. You can come in so we can exchange ideas, because there's with regard to constitutional review of laws, we have also raised our voice about having a judicial reform as well to aid each and every one of us who's committed to respect and upholding human rights, respect for and upholding human rights. This is a commitment we're undertaking. We will provide you all the information that has been asked, and it can be assessed by the Commission itself after we provide it in writing, and it's appropriate as well. I want to see if my colleagues would like to take the floor now to provide any complementary explanation for any doubts that have been raised, or with regard to any aspects that they believe that should be provided. Thank you very much for giving me the floor. Shall I continue? Thank you very much. I just wanted to add to what's been said. As I was said, we will provide you the statistics about how effective the decisions have been, the rulings of the claims that have to do with gender-based violence. We have a order from January about with a feminicide case. This was upholding due diligence and the right of women to lead a life free of violence under the Convention of Belém do Pará, and Law 48 also says that the court has been using as a best practice the application of these provisions. And with regard to the rights of children and adolescents and all this information, we will submit it in writing to you so that you can see that as a best practice of the Constitutional Court, we've been using these parameters of protection.
Gracias.
Thank you very much, Madam Chair. As regards the state, I'd like to make some clarifications for those present here at this hearing. With regard to the query from Commissioner José Luis Caballero, of quite an important query, the state would like to tell the Commission that the political Constitution of February of 2009 has 3 articles that makes the Constitution the law of the land. 3, it talks about international human rights conventions and the American Convention of Human Rights, the Pact of San Jose. Article 3 talks about interpretation of provisions in function of human rights. And Article 156 talks about preference to be given to international conventions when it comes to human rights, but provided they establish more favorable protection than Bolivian law. And then there's another article that talks about the constitutional block, that is, open-ended constitutions that say what are the provisions of the constitutional block and where in human rights we give preference and takes precedence international conventions. The tribunal, the Constitutional Tribunal, is widely represents the population indigenous member who's here right now. For 6 years is the term. This term is ending. It's the 6th year. There's been several different judgments that have defined plurinationality, multinationality, which characterizes our court. It's been mentioned here, Madam Chair, about justice reform. The government is working on this. This is one of the recommendations of the experts group, which said that there should be an overhaul of the entire judiciary and the justice system. And we invite the Inter-American Commission on Human Rights to be part of this major reform of the judicial system, and we'd like you to join in. And we have a lot of work to do, I would say, when it comes to administration of justice. We do it with our authorities, and now we're doing it with the international bodies who have experience, such as this commission. And so it's our experience, and there's been many invitations that have been issued in different periods, and we will continue to issue these invitations to help us. With regard to the election of the judges, the justices on the court, I would like to inform you that on March 2nd of this year, the Legislative Assembly has worked on a bill to call for pre-selection of judicial authorities, which was approved on March 25 of 2023. It was published in March of 2023 as well. However, after an amparo case, the Constitutional Court did not dismissed it because it did not comply with a lower court requirement. We all know that rights can be limited based on limits set forth by the Constitution, provided that there is a law that does so. There was a second rule for judicial authorities, which has also is under review of the Constitutional Court. This is the intent of the national government of President Arce to carry out the elections beyond any criticism that we have. The pressure that we may be under is the mandate of the Constituent Assembly being held for our nation, Madam Chair. So I would like to conclude with a categorical assertion, absolutely categorical. There is no agreement in the national government of President Arce. We can say this clearly, does not recognize and denies the existence of any agreement, much less any mention of any existence of political prisoners. The plurinational state of Bolivia We have no political prisoners in our country. What there are, Madam Chair, in our country are criminal proceedings in compliance with one of the rulings and reports of the interdisciplinary group of independent experts, a more than 400-page report that has been put forward by 6 experts in human rights who have engaged in an exceptional forensic work and within the framework of the Inter-American Commission of Human Rights, and whose follow-up is in the hands of the Inter-American Commission on Human Rights. On recommendation number 5, Madam Chair, if you allow me to, I'm going to have to stop my participation here if it's going to be, because out of respect for the Commission, we've been talking about ideas. This is not a political act. This is not a political hearing. I call on the President to stop these interruptions. They shouldn't continue, or I won't be able to. The fifth recommendation of the GIEA says it. It's not a Bolivian court or a prosecutor. It's an international report of the highest level of one of the 3 major IEIs in the Americas. It says to investigate exhaustively and seriously and fully respecting due process and the rights of the victims and those who are defendants, and to try and apply punishments to those responsible for the crimes in this report. That's what exists in Bolivia, and that is the international responsibility of the Bolivian state, together with the Inter-American Commission of Human Rights, but particularly, Chair, with the families of the 38 people who have lost their lives. 4 years ago, there was democracy was disrupted in our country, and people run into this.
The end of the time?
Muchas gracias, señora Presidenta.
Yes, okay. Okay, can I please have some order in the room? We've come to the end of the session.
Orden en la sala.
We've come to the end of the session, and I would like civil society organizations, the representative of the state. I think we can all agree separation of powers and independence of the judiciary are central to rule of law, central to equal protection of human rights for everybody, and central to democracy. And we must all be vigilant when there are perceptions that judicial independence has been undermined in one way or the other. Over the years, as I've said before, the Inter-American Commission on Human Rights has referenced structural challenges to judicial independence in Bolivia, and this is irrespective of regimes. And I think, so we've listened very carefully to what you've had to say, and we've also listened to the state response. And we want to assure you that the Inter-American Commission on Human Rights remains available and eager to provide technical advisory services to support the guarantee of judicial independence. And with that, I'm going to bring this hearing to an end. Thank you very much.